going to call the meeting of the Illinois Supreme Court Rules Committee public hearing to order. I want to thank all committee members that are in attendance, in particular Justice O'Brien. We have 5 speakers that have signed up. Why don't we begin with Lisa Jacobs, representing the Supreme Court Committee on Juvenile Courts, who will be speaking on Proposal 25-06.
Good morning, Chairman, Justice, members of the committee. My name is Lisa Jacobs, and I am the Vice Chair of the Supreme Court Committee on Juvenile Courts. Our committee is chaired by Circuit Judge Ben Rowe of the 15th Judicial Circuit. I'm glad to be with you this morning to offer testimony in support of the proposed amendment to Supreme Court Rule 307, which would permit interlocutory appeal as a matter of right from orders granting or denying a petition under Article 5 of the Illinois Juvenile Court Act when the state has sought to have a minor's petition for adjudication of delinquency dismissed and the minor tried under the criminal laws of the state of Illinois. In February 2025, the Illinois Supreme Court requested that the committee consider the advisability of a possible amendment to the Supreme Court rules to allow for interlocutory appeal from transfer orders from juvenile court to adult court. Article 5 creates 2 mechanisms for juvenile courts to transfer jurisdiction of a matter involving a minor for prosecution, trial, and sentencing under the adult criminal laws of the state of Illinois. The first mechanism is presumptive transfer, in which the state seeks to transfer a youth 15 years old or older charged with a forcible felony. The more common mechanism is discretionary transfer. In discretionary transfers, the juvenile court has broad discretion to transfer any youth 13 years old or older upon motion by the state if the court finds that there is probable cause to believe that the allegations in the motion are true and that it is not in the best interests of the public to proceed under the Juvenile Court Act. Among the factors to be considered by the juvenile court are the age of the minor, the current alleged offense, any previous delinquent or criminal history, any previous abuse or neglect of the child, and whether or not there is a reasonable likelihood that the minor can be rehabilitated before the expiration of the juvenile court's jurisdiction. If the juvenile court enters an order for either presumptive or discretionary transfer, the minor is then subject to the processes and procedures of the adult criminal court, and upon a finding of guilt is to be sentenced as an adult. This means that the procedural protections of the Juvenile Court Act and the specialized resources of juvenile courts are no longer available to that youth, including but not limited to confidentiality of proceedings, developmentally tailored sentencing provisions, and the rehabilitative services and interventions available in juvenile court. Despite the critical nature of these transfer decisions, under the current framework of the Supreme Court rules and the Juvenile Court Act, orders determining such transfer are not considered final orders for purposes of appellate jurisdiction, nor have they fallen under the provisions for interlocutory appeals. In charging the Committee on Juvenile Courts to consider the advisability of amendments to the Supreme Court rules to permit interlocutory appeals, Chief Justice Tice noted that the court last considered the advisability of such interlocutory appeals in 1979. Since that time, the American Bar Association and the National Conference of Juvenile and Family Court Judges have considered appeals of transfer decisions and have explicitly urged courts across the country to allow for interlocutory appeals. In doing so, the National Conference states, because of the potentially serious consequences of juvenile charges being transferred to criminal court, counsel for the youth should have the opportunity to request expedited interlocutory appellate review if counsel believes that the juvenile court judge has made an error in process or judgment. Similarly, the American Bar Association Juvenile Justice Standards state in relevant part that in order to effectuate the goals of an appeal, no criminal court should have jurisdiction in any proceeding related to any transaction or episode alleged in the juvenile court petition as to which a waiver motion was made until the time for filing an appeal from that determination has passed, or if such appeal has been filed until the final decision of the appellate court has been issued. In response to the court's request, the Supreme Court Committee on Juvenile Courts convened an ad hoc work group to consider these issues and to review existing statutory authority and consider the advisability of amendment to the Supreme Court rules. Retired Cook County Juvenile Court Judge Stuart Katz ably led our ad hoc work group in its considerations, and the group and the committee analyzed both presumptive transfers and discretionary transfers, as I described earlier. The group also considered the existing Supreme Court rules and the provisions of the Juvenile Court Act. Ultimately, the work group proposed language to amend Rule 307, interlocutory appeals as of right, and presented recommendations to the full committee. The recommendations of the work group were adopted without objection by the committee and forwarded to the Supreme Court for consideration at its September 2025 term. The intent of the proposed amendments to Supreme Court rule are simple. Transferring a minor from the jurisdiction of the juvenile courts to be tried and sentenced as an adult is a critical decision with lifelong consequences for that young person, their family, and our communities. As the committee noted in recommending the proposed rule, it is essential to take account of the trauma and delay attached to requiring that a young person be subject to the adult criminal system, enduring a conviction and a sentence that can be up to natural life, before even having an opportunity to appeal the underlying transfer decision. It can take years for criminal cases to get to trial and come to resolution, and potentially years more to perfect an appeal. Any youth who has a valid appeal of a transfer decision would lose years of their life navigating this adult system. And keeping a minor in secure detention during the pendency of the criminal case has significant adverse consequences and is costly for counties and the courts. And the longer a youth awaits disposition, the more likely it is that they will age out of the juvenile system altogether and become ineligible for the rehabilitative resources it offers. This proposed rule takes account of those realities and also takes account of the recommendations of the National Conference of Juvenile and Family Court Judges and the American Bar Association to more closely align Supreme Court rules with these standards. On behalf of the Supreme Court Committee on Juvenile Cases, I ask that the rule be adopted, and I'm happy to answer questions or provide additional information that might aid in your deliberations. Thank you.
Thank you, Ms. Jacobs. Any questions?
I did have one question. Have you received feedback from the prosecution side?
We have not, and I don't believe that there is any objection filed for this hearing or any testimony planned for this hearing.
Has anyone on the prosecution side has there been communication, or has their input been sought and they simply didn't respond, or?
That I'm not certain of. What I can tell you is there is prosecution representation on the Supreme Court's Committee on Juvenile Cases. And this rule would permit the appeal by the state or by defense.
Do you have any sense of how many cases this would apply to where there have been appeals filed in juvenile cases?
I do not, and the committee did not look at that specifically, partly because of the current process. There are probably fewer appeals filed because they have to wait until final disposition, and again, it's very likely that a youth has aged out. So at this point, there are not a significant number of appeals of the transfer decision statewide.
And has there been any workup as to the potential cost of the additional appeals in terms of judicial resources, state's attorney resources?
Not to my knowledge. The committee did consider those issues, discuss those issues, and again, weighed the harms to young people and the need for prompt review of these decisions on behalf of the state or defense.
And recommendation out of the committee that included prosecutors and defense was unanimous?
Yes, it was passed, it was adopted without any objection or concerns.
Thank you.
Let the record reflect those are questions from committee member Robert Larson. Any other questions?
Good morning,
Morning.
Judge Tracy Porter. I wanted to know if your committee had or received the recommendations by the Illinois State Bar Association in regard to Rule 604, 660, and 600A, which seem to be very specific to juveniles in the Juvenile Court Act when you made your proposal to Rule 307.
There was no formal communication or coordination that I'm aware of, but there are members of the committee who did have communication with the State Bar Association. I believe you're going to be hearing a little bit more about the ISBA process. It's my understanding that the ISBA and the Supreme Court Committee had similar goals and came to similar conclusions about the need for interlocutory appeals.
Thank you. Any other questions? Hearing none. Thank you, Ms. Jacobs.
Thank you.
Is Ms. Clark in the room? Next, we'll hear from Betsy Clark, representing the Illinois State Bar Association on Proposal 25-06, again, seeking an amendment to Supreme Court Rule 307, addressing interlocutory appeals as of right.
Good morning, Chairman. Good morning, committee members. Thank you for including us in this discussion this morning. My name is Elizabeth Betsy Clark, and I come before you on behalf of the Illinois State Bar Association as a longtime member of its Child Law Committee. And we are in support of the proposed changes to Supreme Court Rule 307, interlocutory appeals for the decisions of the juvenile court regarding adult prosecution of children, and of the proposed comment to the rule clarifying that the appeals are to be expedited. It might help if I told you a little bit about the how this came to our attention in the Illinois State Bar, and that is that about 2 years ago, Judge Chad Beckett wrote an article for our Child Law newsletter about the process of juvenile transfer hearings in juvenile court, hearings to transfer children to the adult court, and what factors the court should consider and so forth. And at the end of that article, and it is cited in the written comments from the State Bar, Judge Beckett said, "It bears noting that a successful transfer petition under the current law may result in a child as young as 13 being ordered to serve a multi-decade incarceration. Even when those sentences are reversed, multi-year incarceration is still likely due to the way transfer decisions are subject to appeal. The state, for example, may immediately appeal dispositive orders in juvenile cases. By contrast, a juvenile subject to a successful a petition transferring the case to adult court usually must wait until after the adult criminal trial proceedings are concluded. For the victims and their families in these cases, this brings about reversed results in justice delayed. For the minor," and he notes the minor in the case that he was referring to bias, "the result is a 15-year-old waiting 2.5 years after the initial transfer decision for access to appellate review." This then led our committee to consider this issue and bring a recommendation before you for an interlocutory appeal. And while the language is a little different and the placement of the proposed rule is different from the rule from the Supreme Rules Committee, the idea is exactly the same, and we endorse the proposed rule because this anomaly in appellate review cannot stand. Now, you asked Member Larson a question about how the public viewed this, how the prosecution viewed this, how other stakeholders in the juvenile court would view this interlocutory proposal. And the proposal from the Child Law Committee was overwhelmingly approved by a number of ISBA substantive law groups, including Bench and Bar, Corrections and Sentencing, Criminal Justice, General Practice, Human Rights, Racial and Ethnic Minorities, Rural Practice, and Women in the Law, unanimously endorsed by all of those committees that are broad-based both geographically and professionally. And it was ultimately approved by the Board of Governors in February of this year. I would just note that justice may be foreclosed if juveniles are not allowed to appeal immediately from the decision of the juvenile court, because under Supreme Court Rule 604D, as you are well aware, there is a complex process before anyone in criminal court can appeal from a plea of guilty. And as you know, the majority of cases in the criminal court are pleas of guilty. So minors may be, if not given this interlocutory right, foreclosed entirely from appellate review of this extraordinary decision. I believe in your comments you note how extraordinary this decision is, and it is truly extraordinary. Most developed countries follow what we set as an example here in Illinois with the development of the world's first juvenile court, follow international consensus that all children under 18 should be prosecuted in a juvenile court. We do not, and as a country, we have taken exception and reserved the right in exceptional circumstances to treat children in the adult criminal court. But in that respect, we stand outside the rest of the developed world. And so it is even more important for us to provide immediate interlocutory review on an equal basis to children. Thank you.
Thank you, Ms. Clark. Any questions?
Same question posed earlier. Why should we move the proposed rule that you support to the 600 sections of the rule versus the 307? I'm trying to get a better understanding of why you propose a counter position.
Well, we were not aware of the proposal that was going to come, and we heartily endorse either. The outcome is the same, so wherever you decide this should go, whether in 307 or in the 600 rules, that's fine.
And the reason I bring this up in brief is that I sit in the juvenile court, but on the child protection side, not the delinquency side. So in looking at these rules, I would encourage not only the public defenders, but the ISBA to make sure you're balancing what happens in a delinquency case versus a child protection case, and the references in Rule 307 and the 600 rules are not really interchangeable depending on what section of the Juvenile Court Act you make reference to. So that's one of my concerns and consideration of determining whether it belongs in 307 or belongs in the 600 rules.
Thank you. And in that regard, if I'm understanding the proposal, 307 provides for expedited review of the appeal. The 600 series authorizes the appeal of this process. They can be read together, can they not? Or are they conflicting with one another? Because I don't see in the proposals for the 600 series reference to expedition of the appellate process. So are they both required to accomplish the goal that you're pursuing?
I don't have the rules in front of me, and I apologize. I know that there is a separate Supreme Court rule providing for expedition of juvenile appeals. And that is, I believe, in the 600 section. So that would apply.
Okay. And then, given that you've got the information from all these different sources, I'll just repeat the questions that I asked earlier. Any information regarding statistically how often these appeals are brought, how often they are successful, and the likelihood of a far greater number of appeals if the expedited process is put in place, and what those costs would be. Do you have any of that type of information?
Well, I do know, as Ms. Jacobs testified, the numbers of children who are subject to discretionary transfer are thankfully very small. If you look at the number of children, for example, in the Illinois Department of Juvenile Justice subject to adult, who are there on adult sentences, the number is quite small.
And quite small being less than 50, less than 100, less than any number you're aware of?
You're asking me off the, I mean,
If you don't,
the total population of IDJJ children in the facilities is well under 200, and this is a very small percentage of that. So I would not see it adding much in terms of increased number of cases. It may encourage it may encourage better litigation by all parties at the juvenile court stage, and it certainly is outweighed by costs, as Ms. Jacobs pointed out, of incarceration and the resulting corollary consequences as well.
it would be fair to say of those cases that are actually referred through this process, they're for the, generally speaking, for the most serious offenses.
Discretionary transfer, yes, the ones that are referred are generally for charges that are considered more serious, yes.
Murder, sexual assault, that sort of thing.
The most recent data on the cases is really from 2018. It's a report from the Illinois Juvenile Justice Commission, and it does show a breakdown, I believe, of the cases across the state, so I could refer you to that.
Thank you.
Thank you. May I add, though,
Sure.
I find it equally extraordinary that there isn't more data. Thank you.
Before you, any other questions? Okay, thank you. Next, we have Mr. Sam Goldberg. He's representing the Office of the Cook County Public Defender, again speaking on Proposal 25-06, seeking amendment of Rule 307.
Thank you, Chairperson, and the committee for allowing us to make comments on this critical and common sense rule proposal. My name is Sam Goldberg. I'm from the Cook County Public Defender's Office. I'm here representing our office in strong support of this proposed rule change. I think it's worth noting that in the written comment and in the testimony today, I believe that I'm last on this proposal. Everyone is in support of this rule, and as Betsy and Lisa made clear, the entire legal community is in support of this rule change. I will briefly talk about some of my experience, why our office supports this rule, and then give an example of a young person I represented in juvenile court that shows how critical this change can be. So again, I'm a public defender. I have been a public defender for 13 years. I have represented young people in juvenile court accused of a range of crimes, up to including first-degree murder. I have represented young people who are facing discretionary transfer, and I have won and lost those hearings. And I currently represent a young person in adult court who was discretionarily transferred from juvenile court, who is now 21 years old and will not be able to effectively appeal that decision. And before I go into why we support this rule, I just want to lay out what it looks like now. I think it's important to get that perspective. Right now, a child transferred discretionarily from juvenile to adult court cannot appeal until that case is over. What that means is that they sit in, when they turn 18, they'll sit in adult jail. They go to adult court. When they get sentenced, they will go to adult prison for the likely 2 years it takes before the appellate court rules. They will get none of the specialized services of the juvenile court because they cannot appeal until the case is over. Oh, yeah, sorry. I'm just used to walking while I talk. Practically speaking, these cases, as we know, are complicated and they take a long time. So what that means is that a kid who is up for discretionary transfer has to go through the transfer process, has to go through pretrial, has to go through trial, and has to go through appeal. They will likely, as the kid I represent, be 21 by the time the appellate court rules. Juvenile court loses jurisdiction at 21. What that means is that they have no meaningful opportunity to appeal because the appellate court cannot send it back to juvenile court because there's no jurisdiction anymore. This rule makes sense, and the current regime does not. We support the rule because it is fair and it promotes judicial economy. As the rule is proposed, what that means is that a young person who is discretionally transferred will get finality immediately regarding that decision. Finality that they have to go to adult court, which is important for adolescent brain, or if they were erroneously transferred, they can, while they are still a teenager and they are still developing, get all the resources that the juvenile court has to offer and that is focused on reform and rehabilitation. Not only is it fair, but again, it promotes judicial economy. Because if a child is erroneously transferred to adult court, then that person's case has to go through the entire adult court system when it never should have been there in the first place. And these cases are very complicated. So we can avoid burdening the already overburdened adult criminal system by allowing for immediate interlocutory appeal. And I want to finish by talking about a client I represented in juvenile court. We'll call him Amare. He was 15 years old. He was charged with first-degree murder, and the state filed a petition to discretionarily transfer him to adult court. Thankfully, in our case, the judge denied that petition. He went through the juvenile court system, where he eventually did plead guilty to the charge. In the juvenile court system, he had the benefit of specialized resources. So he had social workers at the JTDC. He had probation officers who were specialized and trained on how to work with young people. He had access to programming that only the juvenile court system can offer. Not only did he have access to that programming, but his mother and his grandmother also had access to that programming. Amare finished the juvenile sentence. He is now 24 years old. He's married. He has 2 young children. He has an associate's degree. He has a full-time job. And he has not been arrested since when he was a child at 15. And there will be a time where there is a kid like Amare who is erroneously transferred to adult court. And under the current rules, that kid will not be able to have the support that Amare got that allowed him to turn into that person he is today. Because that person, if we do not make this rule change, will have to sit in adult court, in adult jail, in adult prison. And that is not fair, and that does not promote justice. And that is why our office supports this rule. So I appreciate the time, and I'm happy to answer any questions.
Thank you for that presentation. Anyone, any questions?
So John Spacia for the record. So my question is, it looks like the expedited appeal process, which is the 90 days rule requiring a decision from the appellate court within 90 days, is in the committee comments of the proposal. And so I'm wondering, why is the expedited appeal in the committee comments and not provided for in the rule itself? Or is that somewhere else?
I'm a trial attorney. You're kind of outside my wheelhouse here. I did not write the rules. But sure, makes sense. I don't know if they're somewhere else. I apologize.
I mean, my concern is that you've achieved the purpose of an expedited appeal in the trial court, but I'm just wondering if this expedited appeal is in the committee comments, are you going to get your expedited appeal and a decision within 90 days so that you don't end up in an appellate court for 2 years?
Right. I think we should implement a mechanism that does allow for that kind of expedited appeals. It makes no sense for it to sit for the 2 years it normally takes.
Okay.
Whether that's going to be in Rule 307 or Rule 604 and in the committee, I think the experts here can determine what's best. But yes, I certainly agree it should be expedited. I will say to Chairperson Larson, just anecdotally, Cook County, obviously by far and away the biggest and busiest courthouse in Illinois, I would say there's 3 kids a year who are transferred. It is a very small number, but it is, as Ms. Clark said, such a critical decision that we have to address it to provide fairness for these people whose lives are drastically changed by that decision.
Member Hardy?
My question is, if the appeal occurs, what is the appellate court's standard of review to review the decision to allow transfer to adult court?
The appellate court review just is abuse of discretion. So it's a very hard standard to meet. So there would have to be real error by the trial court to get overturned. And as I think Ms. Jacobs said, both sides under this rule can appeal. Either the state can appeal a denial or the defense can appeal the granting of the petition to transfer.
Any other questions? Member Larson?
Sorry. Just have particular interest in this. Couple of questions. So in the case that you referenced, this was a minor who pled guilty to first-degree murder,
Well, he was charged with first-degree murder. He pled guilty to a lesser offense.
but to a murder offense?
No, it was an aggravated battery with a firearm, but
Okay. And because of the sentencing restrictions in juvenile court, he could not be sentenced to the level of discipline that would have occurred in the adult court?
well, if you have a second, I can give you the full context, but Illinois does have they have another legislation called the EJJ, I can't remember what it stands for, but effectively what it means is a young person gets 2 sentences. They get a juvenile sentence and an adult sentence. This is not part of the rule, but just for context for you. So he was subject to EJJ. So what that meant is when he got sentenced, he got the juvenile sentence, but he also got an adult sentence, what he would have gotten if he'd been transferred to adult court. And basically, if you can stay out of trouble until your 21st birthday, then the adult sentence is permanently stayed. It never happens. But if prior to your 21st birthday, there's probable cause that you picked up an offense of any kind, then the adult sentence will kick in. So for someone like Amara, that was where he ended up, if that makes sense.
It does. And then my last question, I promise.
That's okay, I'm happy to talk.
Do you have any sense as to the number of cases wherein it was actually held by an appellate court that the transfer was an abuse of discretion?
I could not find any last night because I figured this question might come. And I think the practical reason I couldn't find any is what I said in my prepared remarks, which is most discretionary transfers are the serious offenses. In my personal experience, I've only ever had first-degree murder. Those cases take forever, especially ones of this complicated nature. So by the time the appellate court has it, and every time I've ever done it or seen it, the kid is no longer a kid, they're now 21, and so the appellate court cannot send it back to juvenile court. So again, they lose that meaningful opportunity to appeal. So the appellate court has not had much opportunity to address these issues because of the nature of the system as it stands, how long everything takes, and that they can't appeal until it's a final and appealable order after trial.
Any other questions or comments?
All right, thank you.
Thank you, Mr. Goldberg. Next, we will have Judge Ortiz representing the Commission on Access to Justice, speaking on Proposal 25-08, which seeks amendment of Supreme Court Rule 10-101 regarding standardized forms. Thank you.
Thank you. Good morning, Mr. Chairman, Justice O'Brien, and ladies and gentlemen of the committee. I'm honored to be here. My name is George Ortiz. I'm a judge and I chair the Access to Justice Commission, and I'm very pleased to be here to discuss proposed amendments to Supreme Court Rule 10-101, which pertains to standardized court forms. And the rule contains several areas of ambiguity on key issues, such as whether prior versions of statewide standardized forms should be accepted for filing, what constitutes a modification to a statewide standardized form, and where standardized forms may be accessed. And these ambiguities have contributed to inconsistent practices across the state. When addressing recurring issues, it would be helpful to point to clear, specific provisions within the rule, and the proposed amendments are intended to provide that clarity and provide for greater and promote greater uniformity statewide. Importantly, these changes do not alter the underlying intent of the rule. Rather, they are designed to better support clerks, court staff, and self-represented litigants. And so the key proposed amendments are, first, acceptance of prior versions of statewide forms. One of the primary clarifications is that prior versions of statewide forms can be accepted for filing. Specifically, the use of an older version of a statewide form by itself should not be a basis for rejection of a filing. This issue has arisen in practice, and rejecting filing solely for this reason is not consistent with the intent of Rule 10-101, which is to enhance access to justice and court efficiency. This clarification is also necessary because not all courts consistently link to the most current version of the statewide forms on their county websites. Some county websites link directly to specific form files rather than to the Illinois Courts Forms landing page. As a result, outdated versions may continue to circulate. To address this, the proposed changes include language identifying best practices, specifically encouraging courts to link to the Illinois Courts Forms landing page for the current versions of the statewide forms. And we believe this should help ensure that users access the most up-to-date versions and discourage older versions from continuing to circulate. While the goal is that the most current version of a statewide form be used, version differences alone should not create a barrier to court access. The second proposed modification is defining what constitutes a modification of statewide forms. And the proposed amendments introduce a clearer definition of what it means to modify a form. Adding information to a form is permitted. However, altering the structure or intended purpose of the form is not permitted. The proposed amendments further clarify that the underlying PDF of a statewide form may not be modified. There have been instances where users or counties altered PDF forms to serve different purposes, while the form still stated that it was approved by the Illinois Supreme Court. Because these edits occur at the file level, there are often no visible indicators, such as strike-throughs or annotations, that the statewide form has been changed. The form appears identical to an officially approved version, and we feel that addressing this in Rule 10-101 is the most effective manner of managing this issue. The proposed amendments would also provide clarification on mandatory use forms. While Rule 10-101 generally does not require the use of statewide forms, certain forms are mandated by statute or rule. And the current version of the rule does not explicitly reference these mandatory use forms. The proposed amendments clarify that where a statewide form is required to be used by statute or rule, its use is mandatory. The proposed amendments also provide clarification on the definition of forms. A clarifying definition was added to ensure that all elements of statewide form sets are covered by Rule 10-101. Forms would include any statewide standardized court form, additional or related forms, instructions, and other informational materials developed or provided by the Commission. In addition, the proposed amendments would provide clarity for clerks and courts on providing forms. The proposed amendments add a comment to the rule clarifying that clerks and court staff can provide statewide forms to court users without it being considered legal advice, even if the user does not request a specific form by name. The proposed amendment, or proposed comment rather, references the existing Illinois Supreme Court policy on assistance to court patrons by circuit clerks, court staff, law librarians, and court volunteers, safe harbor policy for short, which states that clerks and clerks and courts may provide statewide forms based on a user's description of their legal issue. This does not constitute the unauthorized practice of law. Finally, additional updates, in addition to the changes described previously, the proposed amendments include several organizational and structural improvements to Rule 10-101. These updates are intended to improve readability and usability for all court stakeholders. And so thank you for your consideration. I'd be pleased to try to answer any questions you may have.
Thank you, Judge Ortiz. Any questions?
The ISBA raised one tiny, picky point. In paragraph F, it says handwritten or typed additions are permitted. Does a strike-through count as an addition or not?
So, no, it doesn't, but I'm aware of that comment, and we have no objection to adding and strike-throughs to the language so that Section F would read, handwritten or typed additions and strike-throughs are permitted. So we have no objection to that.
One of the microphones.
Yes, there you go.
Thank you. Got it. My question was with respect to Section F as well. In reading the proposed rule and proposed changes, it seems to me like someone could review that and read that as saying that they could not edit the form in a way. For instance, I will take standardized forms in my office, edit them to compile a form that is consistent with my firm's formatting requirements, but it does not say approved by the Supreme Court, right? It's a Word document that we then transfer. I read the proposed rule to sort of eliminate my ability to do that. Would you be opposed to language adding clarification to your point, meaning that you cannot file a document that is edited or modified in a way inconsistent with this rule that says, quote, approved by the Supreme Court?
I think that that would be consistent with the intent of the proposed amendments.
Thank you.
Any other questions or comments? Hearing none. Thank you, Judge Ortiz.
Thank you. Thank you very much.
The next speaker will be Supreme Court Clerk Cynthia Grant, speaking on behalf and representing the E-Business Policy Advisory Board, addressing Proposal 25-10, which seeks amendment of Supreme Court Rule 9 on electronic filing of documents. You may proceed.
Good morning, Mr. Chairman. Good morning, members of the committee. My name is Cynthia Grant, and I serve as the chair of the E-Business Policy Advisory Board. On behalf of the board, thank you for your time in considering this matter. For a number of years now, the board has focused on standardizing the reasons why court filings can be rejected in an attempt to reduce the number of filings that are rejected throughout the state. The proposal in front of you is in furtherance of that objective. In the spring of 2025, the board was informed that e-filings in certain counties were being rejected if there was no signature on the document. Now, the board has taken the position that a lack of a signature on a document is not a reason why a clerk should reject a document. If there was a question about a signature, it would be left to the judge to decide. Further, the issue of rejecting an e-filed document in particular without a signature was problematic to the board because, as many of you know, in order to submit an e-filing, you have to create an account with one of the e-filing providers. So when a filer submits a filing, we know who submitted it. As such, the board believed a logical solution to that problem would be an amendment to Rule 9, stating that if a filer has submitted a filing electronically, using their own login and password, that will suffice as a signature requirement pursuant to Rule 137. Mr. Chairman, I stand willing to answer any questions of the committee.
Thank you. Any questions? Hearing none, thank you very much.
Thank you.
That's the last speaker who signed up for public comment. Hearing none, I think we can sit in adjournment. Thank you all for attending and participating.